My name's John Hodgkinson. I'm a lawyer here at Kreisson. My main concern at Kreisson is corporate and commercial work. Kreisson as a whole, though, is a construction specialist firm. I sit on the periphery of the lawyers here who do construction disputes and contracts. Okay. Firstly, this presentation is just general advice. It's just to alert you to the concerns about the subject matter. If you've got a particular problem, you should consult us and get advice which reflects your particular circumstances. It's a bit like financial advice. The first thing that I want to take you to is the various forms of company structures that are available. You can be a sole trader. If you're a sole trader, you have unlimited liability for mistakes, unlimited liability for debts. You put your own personal assets at risk for those liabilities and debts. And you've also got limited access to capital. You can only borrow so much from your own bank or take so much out of the piggy bank in the backyard. Another common arrangement is partnerships. Every partner you bring brings new capital to the business, but you retain that unlimited liability. Every partner is fully liable for all the debts of the business if you're organised as a partnership. All the partners are jointly and severally liable. That means any individual partner can be responsible for the totality of the debts without necessarily being able to demand a contribution from another partner. Your personal assets remain at risk. Probably the most common arrangement in the industry nowadays is that of a proprietary limited company. That gives you some advantages, certainly advantages over the sole trader and partnership arrangements. Your personal liability is limited to the capital that you contribute to the company. Your personal assets are not at risk unless you give a company guarantee. You've got a greater access to capital. It's easier to gain funds both from debt and from new equity. However, there's lots of state and federal laws which impose liability directly on the directors of a partnership, particularly in relation to WHS matters, taxation, even the company law, certainly in the case of an insolvency. The fourth common arrangement, which is generally described as the best possible arrangement, is to have a proprietary limited company as trustee of a trust, a discretionary family trust. Your liability is limited. It's the assets of the trust that are at risk. There's no recourse to any individual beneficiary of the trust or to the directors of the company. You've got significant tax advantages with a discretionary trust. I'm not a tax agent, so I'm not going to tell you what those advantages are, but I'm sure that many of you are organised in this fashion. The management of a company, which is at the focus of today's discussion, is governed by at least two different documents. Firstly, there's the Corporations Act 2001. It's federal government legislation. It's awfully long. It's 5 volumes. There are 10 chapters and thousands of sections. It covers a great range of things. It covers proprietary limited companies, small companies like many of your members. It covers the largest of public companies. The biggest companies, public listed on the ASX, are governed by the Corporations Act, the same as the smallest companies. Large proprietary companies are a different group. If you've got more than $20 million in assets or you meet other minimum tests, you have increased obligations under the Corporations Act for compliance. It also covers companies limited by guarantees. The charities laws, such as our last speaker, they will be organised as a company limited by guarantee. Again, it's the Corporations Act which regulates their internal arrangements. The Corporations Act covers other things too: investment advice, capital raising, managed funds. So strictly speaking, the investments in your superannuation is managed through managed funds, and they in turn are managed under Section 601 ED of this piece of legislation. So you can see it's a very complicated thing. The next key document in a company is its company constitution. That's a written document which is lodged with the Australian Securities and Investment Commission. It contains either a default set of what are called replaceable rules, which are a copy of what's in the Corporations Act. However, you're not stuck with those replaceable rules. As the name suggests, you can replace them with your own bespoke set of regulations, internal regulations for the operation of the company. It can contain anything that a majority of the members of the corporation, the shareholders of the corporation, want to put in that document. But however, it is not an entirely helpful document. There was a book written in the 19th century, early 19th century, called Democracy in America by a Frenchman called de Tocqueville. Please excuse my pronunciation of his name. And he spoke about the tyranny of the majority. You know, in the absence of any intermediary institution, to use his words, a majority of voters in the US, for example, can take advantage or treat minorities very badly. It might be a segue to the present situation over there. That book was written in in 1811, I think, or thereabouts. Even after the First Amendment to the US Constitution was written, the Freedom of Speech Amendment. It was a direct result of the unthinking despotism that was shown by the majority, mainly white population of the US at that stage, towards unpopular minorities, particularly blacks in the northern part of the country, and the mob violence, excuse me, that was exhibited towards people who are against the 1812 war. De Tocqueville said that that was the great failing of democracy, that the majority of members could simply outvote and force their will over the minority. Exactly the same thing happens in proprietary limited companies. Under the Corporations Act and the replaceable rules and the standard forms of constitution, a majority of directors or a majority of shareholders can arrange the internal affairs of the company as they choose. They can take control of the company, much to the detriment of minority shareholders. And there's plenty of examples of it. I've spent half of today dealing with a company dispute where exactly that has happened. The majority shareholder, who owns about 3/4 of the equity, has treated the company as if it was his own private piggy bank, much to the detriment of the shareholder who only holds 25% of the equity. The way to overcome that problem is at the centre of tonight's presentation. It is possible for all the members of all the shareholders of the company to enter into an agreement between themselves. In fact, it's extremely common. Any well-run business that's organised as a proprietary limited company will have a shareholder agreement to which every one of its shareholders is signed up. That can cover a range of things, which I'll speak about in a few moments. But it is a unanimous agreement and prevents the sort of oppression about which I've just spoken. It means that the minority shareholders can't be outvoted on any subject of importance to them. One of the advantages of having a shareholders agreement is the ready capacity to get unanimous agreement to introduce new shareholders and therefore new capital into the company. I said before, with a partnership, you've got a limited capacity to add new partners and introduce new equity to the business. A company, it's much easier to do. When you introduce a new partner to a partnership, it actually induces the dissolution of the former business and a reconstitution of a new business around the new partners. But a company has perpetual succession. It continues in existence. It doesn't have to reorganise its affairs simply because it's introduced a new member or the new capital that member has brought with him, more importantly. The other thing that a shareholders agreement will ordinarily do is set out a procedure, set out the rights for all the members, all the shareholders in the company to attend director meetings, to attend shareholder meetings, and not to be voted down on a show of hands. It can change the information requirements that are in the legislation so that minority shareholders aren't kept in the dark about what's going on in the business. It can effectively give veto rights even to someone with a minority share, a very small minority share, so that resolutions of the company in general meeting become effectively unanimous. In many companies, particularly the smaller proprietary limited companies, that's a great boon to their internal operations. However, it can also work the other way. If all the shareholders who have signed up to a shareholder agreement in a consensus about it, it can give some shareholders an even greater say. You can appoint, for example, what's called a managing director or a governing director, who has virtually autocratic control over the internal management and operation of the company. In some companies, that's a good thing. Another advantage that can be dealt with by a shareholder agreement that's a lot more difficult without one is the agreement between all the shareholders about a dividend policy. Everyone in business is in business to make money. If you're not there to make money, you have to question why you've taken the risk. Under the present law, a company can only pay dividends to shareholders if three tests are met. Firstly, it has to have sufficient net assets. Secondly, the dividend has to be fair to all shareholders. That's sometimes quite problematic. And thirdly, the payment of a dividend can't prejudice the capacity of the company to pay creditors. So if you pay dividends to yourself and leave no money for B&C Sands, for example, well, you're in trouble. You shouldn't be paying the dividend. Shareholders' expectations about returns can conflict with those three legislative requirements. By dealing with a dividend policy in the shareholder agreement, you can overcome potential disputes about the retention of earnings within the company, retained earnings, or the distribution of those earnings amongst the shareholders rather than as wages. Another advantage of a shareholders agreement, a great advantage to the company, is that there is not a word in the legislation about the ongoing obligations of confidentiality and competition by shareholders. Sure enough, a director is prohibited from preferring his own interests over those of the company, but nothing stops a shareholder going off and doing exactly as he pleases, setting up a business in competition, for example. But a shareholders agreement can put those restraints on a shareholder, can put restraints on a shareholder even after it ceases to be a shareholder for a reasonable period of time. It can oblige shareholders to keep trade secrets, keep your customer lists to yourself. It can prohibit shareholders from disparaging the company or its directors or its co-shareholders. They're all useful provisions in a shareholder agreement, provisions that you won't see either in the Company Constitution or in the Corporations Act. This is the biggest benefit of the lot. A shareholder agreement can provide an enhanced exit strategy if in case one of the shareholders wants to sell its interest, perhaps to the detriment of others. It's really easy to put in drag along, tag along, or preemptive rights in the agreement. They're jargon terms. Accountants will be familiar with them. For everyone else, a drag along right, if a majority shareholder wants to sell its shares, then it has to do so on the basis that the purchaser buys everybody else's shares. It buys the whole business and not just part of the business. A minority shareholder probably will like that arrangement. Tag along rights are not too dissimilar. A majority shareholder can't sell without obtaining a similar offer for the minority. It means that a minority holder, if he wants to sell, he can do so. If he doesn't want to, well, we can't make him. Preemptive rights. That means that if a majority shareholder or any shareholder wants to sell, then he's got to offer its shares to the other members first before it goes to any third party.
Oh.
Right? That means that you know who your partners are in the business at all times. They've got to come to you first if they want to exit the company. They've got to get the same price for your shares as they're getting for their own. Now, they can't sacrifice your interests. Usually, if a minority shareholder wants to sell its shares, the purchaser doesn't pay as much as market value would otherwise indicate, because he's not getting control of the company. But with a shareholder agreement, you can overcome that difficulty. And the third thing, dispute avoidance. I'm a lawyer. I go up to court once a week, and most of the fights are in the corporations list of the Supreme Court. You don't get out of that place for less than 200 grand. If you have a fight about the internal management or the fight between shareholders in a company, it's a very expensive business. The usual fights are about breach of directors' duties, about shareholder oppression, minority oppression, or simply to wind up the company because it's just inequitable to do so because one shareholder is running it for his own benefit and not for anybody else's benefit. It's a specialist list in the Supreme Court with two very, very good judges. So the decisions are usually well structured, but it's QCs at 10 paces. It's a place that you don't want to be, and you probably can't afford to be in many cases. But there are other ways to deal with a company dispute. One is direct negotiation. On Thursday last week, we went in, we were about $1 million apart. We settled it after 6 hours, I think it took, just between the accountants, a couple of lawyers who kept their mouths shut, and the shareholders, the two main shareholders in the business. One wanted out, the other one and wanted too much money. The other one didn't want to pay him quite as much. They settled it. They reached an agreement they can both live with. Now, it wasn't what they wanted, but they can both live with it. They've saved themselves about $400,000 in value one way or another. Another method, which is commonly used in these shareholder agreements, is intermediated negotiation, where you get a third party who's specially trained to sit between you and do the shuttle diplomacy or some other method to help you reach agreement, even where there's a lack of trust between the two sides. Almost invariably, when you get to court, you're sent away to mediation anyway. So arranging it as a matter of agreement is often a good step. If the only dispute is about what the company's worth and what shares are worth, then expert determination is another method of dispute avoidance, which often works. However, I find that people aren't terribly keen on the result because it's being imposed on them. You know, they don't get a say in the outcome. They just hand their documents over, hand over their financials, and someone then tells them what their company's worth and how much they've got to pay. And I find most people a bit disgruntled by that. But if you don't have an arrangement in a shareholder agreement about the avoidance of disputes, it's likely that you're going to end up in court having a very expensive fight. That's a very quick summary of the advantages of having a shareholder agreement. I've got several matters on my desk right now where there are disputes that have arisen because the people who set up a company never touched it after they got their accountants to buy a shell company. Never thought about these sorts of issues, never dealt with them until the crap hit the fan, so to speak. I would urge everyone here who's structured as a proprietary limited company to check that they've got a shareholder agreement in place, that it's current, that it meets their needs, and addresses at least these sorts of matters that I've covered tonight. If you want information about changes to the building industry, we have an ebook. It'd be remiss of me not to draw that to your attention. And I'm happy to take anyone's questions about the topic I've just covered in tonight's presentation.
Do we have any questions out there?
I have a question, if I may, through you, Mr. President. Now, probably a little bit, the director law, that has that been passed where the directors now have to have a number, individual number, a national one?
Yes, that's the stop. Once upon a time, if a lot of you remember the bottom of the harbour schemes, I would walk down to the domain, I would find a derelict, I would give him a bottle of metho, get him to sign the documents, and he'd be a director of the company, and then I'd take all the tax returns and throw them in the harbour. He would be the only person the tax office could chase, right? There are lots of phantom directors out there. If you do searches, you often find people who, with names like Mickey Mouse, Daniel Boone, who else have I come across? You know, all obviously phantom directors, not real people. This is a method by which the ASIC and also the tax office are keen to ensure that directors that are nominated actually exist.
I mean, we have been calling for that for the last 20 years, but has that been passed? I knew that was before the Parliament, but has that been passed yet?
Good question. I have an understanding it has been, but I'll take that on advisement and come back to you, John.
Good on you. Thank you very much.
Anybody else got a question that they want to put forward before we wrap up for the evening, or any even general comments they'd like to air? Have we got one in the chat box? What's it say? If you're a company as a non-executive director, how can you limit your personal liability?
Take an interest in the company's affairs, be inquisitive, go and ask questions, literally. I was general counsel at a very large state-owned enterprise for some years. The executive directors would turn up once a month. Never saw them otherwise. The management of the company was able to bamboozle them by keeping them in the dark. Those directors were personally exposed for any poor decisions that they had made as a result. An inquiring mind is the best defence a non-executive director can have.
Thanks. I see George Wrench came off mute. Do you have a question, George?
I do. Thank you, Mark. John, just that ebook from your practice, is that available on your website? And
absolutely.
Can you tell us very briefly just a little of the content of it? Is it the current legislation changes quite what?
No, we've got other ebooks about the recent changes to design laws. I think this is a more overarching one, a bit of an omnibus document, drawing your attention to a range of changes rather than going into any of them in detail. We have various experts here who follow the changes over the years to the SOPA legislation in particular, to the recent design changes. We've got a couple of fellows who are really up on the changes for cladding laws and the laws affecting private certifiers as well.
Thank you, John. Thanks.
I have a feeling that's probably everyone. So that I might leave it there. Thanks, John.
Thank you for your time.